Right, so here we have the third topic on the Torresn system, where we're dealing with equitable interests, unregistered interests in the context of Torresn's land, and the arrangements for compensation for loss. So this is our last topic on the Torresn system, but the features of the Torresn's framework travel right through the unit, because we are looking at lots or parcels of land that are Torresn's title. So these underlying ideas and concepts travel right through the subsequent topics in the course or in the unit. But with this third substantive topic on the Torresn system, we're tackling this idea of how does the system of registered title or title registration deal with equities identification of interests in land, and when you've got interests that may be able to be registered but haven't yet been registered, how do we accommodate those in a system that seems to focus on the interests of entities that have registered interests? And we find that the system makes accommodations for the recognition of other interests, even though not on the register. And there are mechanisms available to deal with unregistered interests. The issue around compensation reinforces the assurance principle, the Torresn system, and we will have a brief look at just some of how that works. But today, that's also a little bit more complicated, as I've been commenting on in the previous lectures, with the strategy to privatise and commercialise Torresn's register in some jurisdictions, not Queensland, but in other jurisdictions. So I'm just going to screen share the slides now. And as we travel through this topic, this last topic, it's really, I think it's important, as always, to yes, you know, what are we seeking to understand? What are we seeking to grasp in this topic? But don't get lost in the forest of detail and case law that at times can seem a bit challenging. Fact scenarios can seem a bit challenging. The case book, a little bit challenging in terms of material there. But again, it's a manageable chunk that we're doing in this third topic. That's how I've broken it up for you. But it's what you need to focus on is the fundamentals. What are the fundamentals that I need to take away in my understanding of this particular area of the Torresn system, and how might they be assessed going forward? And we know that these areas can be subject to assessment, as we will no doubt see going forward. So what are we concerned about here in this topic in terms of our objectives? To appreciate the priority between competing registered interests, or the order mostly is the order of registration, to identify and evaluate priority between unregistered and then subsequently registered interests, to look at the priority issue between unregistered interests, to look at the priority between prior equity and an unregistered interest, to look at how do the principles around priority disputes in regard to interests in land that have been generally developed, how do they work in the context of the land registration system, which is the Torresn system, where registration is the critical event, if you like, in the cycle of an interest in that system, and indeed gives rise to the interest upon registration under that system. And then also to, as I said, finishing off by looking at the provisions of state guarantee and the compensation arrangements with regard to that underlying and reinforcing the assurance principle. You'll see that there just the relevant part of Chapter 5 is 5.162 to 5.225 capital C, and also in the Q&A book, the relevant part there, and then the further reference reading the real property law in Queensland, which I referred to previously. That is also something that you can have a look at, and it just helps to, if you've got access to it, not prescribed, but it just helps to clarify some points sometimes in some areas with regard to what's going on in Queensland. But my notes, materials and so forth give good coverage around the position in Queensland. And just another point, just as we start processing through the topic, when you're looking at the casebook, you're focusing on the relevant position in Queensland. Okay, you know that the casebook is covering all the jurisdictions. You're looking for those the relevant discussion, identification, relevant discussion of the sections of the Land Title Act. Insofar as the case law, again, I've made this point before, but insofar as the case law relevant, pertinent, helpful in explaining the position in Queensland. Some of the cases, of course, are dealing with situations in other jurisdictions, and if it's isolated to that and the situation in Queensland is not the same, then that's of less relevance, maybe as a point of comparison, but of less relevance. So as you're working your way through the casebook material, you're focusing on looking for what's the situation in Queensland, what's the governing law in Queensland. So, we've got those key terms, looking at different types of interests. Caveat's an important idea, important concept in this topic in terms of statutory arrangement that is relevant in the context of unregistered interests and this idea of the priority dispute arrangements. So we look then at the critical legislation, and of course we're focusing on the Land Title Act. To some extent you can refer also to the Land Title Practice Manual. So I just want to show you, so I'm just going to stop screen sharing that, and I'm going to screen share those provisions from the Land Title Act for us. So we can see there that Section 181, an interest in a lot is not transferred or created until registration. Okay, important understanding the order of things here under the Act. Section 177, if we just scroll back up. So the order of registration of instruments and clearly how they're presented for registration forms that basis. Instruments affecting a lot, including instruments affecting or creating an interest in a lot, must be registered in the order in which they are lodged. Okay, you can see there are some qualifications to that in the further subsections. And then there's an example to show you something that may arise in the context of subsection 3. So have a look at that. Remember, the examples are not actually part of the legislative provisions, but helpful guides in terms of understanding how the provisions operate and have effect. So it's important, as always, to go first to the relevant provisions of the legislation. For us, that's the Land Title Act in Queensland. Then go to the explanation and the case law that's helpful in better understanding the position under the governing legislation in Queensland. So I'll just stop screen sharing that and go back to the slides. Right. So the first area we look at is this area of equitable interests and unregistered instruments. And you'll see that the discussion of this theme starts on page 534 of your casebook. Now, we start with this early High Court decision of Barry and Hyder. And, there's a little bit of complexity in terms of the factual situation in Barry's case, if I can refer to it that, in terms of transfers, in terms of issuing of new certificates of title for partial, component in relation to the land, involvement by solicitors, of course, and loans being made, and mortgages being set up, and so on. And the issue arose in Barry's case about what was the nature of the entitlements of these parties in this situation, and it brought us to this idea of, well, does the Torresn system deal with equitable interests? How does it deal with equitable interests and interests that haven't yet been registered? Because that was tossed up in the fact situation in Barry and Hyder. So have a look at the facts. It's explained for you in the notes, and there's a diagram there if the diagrams are helpful. I know that some people aren't necessarily spatial thinkers, but I think diagrams can be helpful sometimes to explain complicated factual matrix. We then come to the reasoning, and this is documented for you in the casebook and also in my notes, the leading judgments of Chief Justice Griffith and Justice Isaacs, just in terms of how do we understand the basic points here, the basic principles. So Griffith makes the point that equitable interests and claims in land are recognised by the Torrens Acts. Okay? So just because we've got a system of title by registration, as we subsequently came to understand it through Bresvar and Wall, as we've seen, it didn't mean that equitable interests and the role of equity is totally irrelevant to this system of registered interests. And here we also had, for the point being tossed up by Griffith back in, again, this is in 1914, an identification of the caveat provisions. We'll come to those shortly. Very important, these caveat provisions in the Land Title Act and their role in relation to unregistered interests. So Griffith makes the point that the caveat provisions, they allow an unregistered instrument may create a claim which is cognisable by a court of justice, and the caveat is the means designed for the protection of the right of the claimant. So we're starting to give us a bit of an idea of the role of the caveat in this situation. In terms of what Justice Isaac said, again, he's making the point that Torrens statutes don't affect other things, right? So they're outside the framework of the Torrens legislation, contracts, for instance. So no issue, the proprietor can contract as he does or as she does, and there are obligations to fulfil the contract, and these will depend on ordinary principles of law and of equity. They're not linked to the Torrens framework. And he makes the point that the provision in denying effect to an instrument until registration does not touch whatever rights are behind it. So he's trying to sort of say that these rights, these obligations that have arisen as a consequence of what the law otherwise recognises will continue to abide. Okay? Parties may have a right to have such an instrument executed and registered, and that right, according to accepted rules of equity, is an estate or interest in land. Okay? So basically in this early decision, 1914, court is struggling with a scenario where there are unregistered interests, equitable interests. How does the system accommodate that? And a comment on the role of the caveating provisions. So remember that when you're reading Barry and Hyder, a little bit challenging in terms of the fact situation, but remember the rationale for why we're still having a look at Barry and Hyder all these years later. So from that early decision, we then move immediately to this idea of the caveats. The caveats, and then subsequently we'll have a look at what are referred to as the settlement notices under Part 7A of the Land Title Act, and that's something a little bit different, but has a purpose in relation to unregistered interests. We'll have a look at shortly. So what is a caveat, right? And we find there that immediately we're taken to the Land Title Act, critical provisions within the Land Title Act, and there's also, you can see reference there to the Land Title Practice Manual. So I just want to screen share those with you. So we see in the Land Title Act, coming back up to Division 2, Part 7, Division 2, caveats. Here we are. It's got its own part. It's so significant, it's got its own division within the part of the Act. Just move that across there, that's a bit clearer. Okay, so, and we see there, if we just, you can see there, I saw on the slide just a little bit earlier, and I'll go back to those shortly, with a reference to there's 121 requirements of caveats, 122 lodging of a caveat, 124 the effect of lodging a caveat. It's an important provision, 124, and we can see that who can lodge a caveat. A caveat may be lodged by any of the following. That's under section 122, and note in particular 1C, the registered owner of a lot can also lodge a caveat. And then we also see 125 dealing with withdrawal of a caveat, process there. 126 dealing with the lapsing of a caveat. It's very important. What are the parameters around how long a caveat lasts and continues? This idea of lapsing of caveats is not the same in every jurisdiction, but it's governed by the legislative provisions. And in Queensland, that's section 126. And then we've got 127, removing a caveat, 128, cancelling, and you can see further matters there, 130 dealing with compensation for an improper caveat. So it's, in this context, what's important is, there's a fair bit of words and language and so forth there. Try and get an overarching view of the provisions. Good to see it in its totality, then come back to what I'm emphasising in the notes and slides with regard to the key provisions that we need to be focusing a bit on, but just get an overall impression of how the legislation is dealing with this important area. If we go across to the Land Title Practice Manual, right, you can see, you can access this from the Queensland Government Business Queensland website, and I'll just pull up the intro part here, because you can see, as we've referred to the LTPM previously, but you can see the range of matters that are dealt with under the various parts of the Land Title Practice Manual. Part 11 deals with caveats, right? And we find that there we are, and you can see caveats there. It's a little bit small, but that is providing understanding, explanation around the strategy, and then also you'll find it deals with forms and processes and procedures as well. So just stop screen sharing that and go back to the slides. So that's the legislative framework that we need to be mindful of. So we're now going to have a bit of a look further into how the caveat framework works. Just remember, of course, that we're focusing on the arrangement in Queensland. We'll start to have a little bit of a look at some case law in a moment. That needs to be accommodated to the position in Queensland. Okay, it may be looking at the position in another jurisdiction where the provisions are not identical. And your casebook makes comment on that. And this is, caveats are discussed starting on page 539. And, just an example of that, and we'll come to a few points in a minute, which I'll just refer to in the slide. But for instance, on page 541, at paragraph 5.171, there is clear identification of the position in Queensland. Legislation in Queensland permits, right? So as soon as you see that, that's what you need to identify. Underline, highlight that, whatever, okay? So the position is not identical in the jurisdictions. So again, just emphasising, we're looking at what is the position in Queensland, what are the relevant provisions under the LTA, and what do we need to draw out of that to get a sense of how these caveating provisions are relevant in the context of unregistered interests and equities identification of interests that are off the register, if you like. Okay, so you can see there just some discussion that the holder of an equitable interest in land is vulnerable to registered interests. Yes, of course, because the registered proprietor has this protection of indefeasibility. Right? If there aren't any exceptions that affect that indefeasibility, as we've seen. The caveat provisions provide a mechanism of protection to holders of interests that are in this vulnerable group, if you like. Okay. Quite what the role the caveat plays in that process has not been entirely settled over time. There's been some countervailing views around that, but we'll come shortly to see an abiding significant decision by Chief Justice Barwick, which focuses on the protective nature of the caveat. We'll come to that shortly. So in section 124, which we've just identified the effect of lodging the caveats from a legal point of view, important. The lodgement of the caveat has the effect of forbidding the registration of a person as transferee or proprietor of an interest, which may affect the estate or interest. So it basically puts a bar on any further activity in relation to the title until the substance of the caveat is being dealt with. And the process for lodging the caveats is in accordance with section 122 by the holder of the unregistered interest or by the registrar or by the registered owner. If you go back to section 122, who may lodge a caveat? And you'll see there's a range of types of individuals that can lodge a caveat. Okay. So in terms of the general idea of caveats and unregistered interests, we need to think about, well, what is the test and the basis for the caveating provisions? How do we apply the test? What is this idea about arming conduct? What does that mean? How does someone, if you like, arm someone with the capability to achieve a particular outcome? How does caveating fit within that process? Now, in terms of some comment in the case law about retention of title deeds, we just need to remember that in the modern period, two things. One is that, of course, in Queensland, we have a computerised system, as do most other registries, but computerised system in Queensland. So we have electronic indefeasible titles or certificates of title. They don't issue as a matter of course anymore. So this idea of title deeds, not really the terminology we need to be using. And we also need to think about, well, how does that have an impact where these documents of title, the certificate of title or indefeasible title, is not actually issuing? Okay, think of this as part of how technology is affecting the circumstances in which some of these ideas and the framework of law will be applied going forward, and indeed in the current situation, for which the historical case law doesn't really accommodate entirely. The process for lodging documents for registration, again, in Queensland, we now have e-conveyancing, and we understand that within the e-conveyancing framework, even though not mandated in Queensland at the moment, it's the case that documents are being lodged electronically through that environment, if that's the situation. In any event, even if we're not operating under e-conveyancing, documents get lodged and scanned in and are stored electronically, those that are subject to registration, transfers and so on, mortgages, etc., in the system. So we just need to be conscious of that current environment of how documents actually find their way into the system and on the register, if you like, and then the interests, the registered interests that are so recorded. Just think about the relevance of notice. That is, if you're aware of something, you have notice of it in a technical legal sense. What is the impact of that in the context of the Torresn system? We've seen that before. And then, which we'll come to shortly, and that is settlement notices under Part 7A. And the settlement notice provisions, again, are not reflected through all the jurisdictions, but Queensland was a bit of a trailblazer in this area, and they've now subsequently been picked up in other states, New South Wales, and more recently in South Australia, as a way of providing a framework of protection for those who have an interest in land between entering into a contract of sale and purchase and settlement of the transaction, where the title is then transferred to the incoming owner or the purchaser of the land. In terms of screen sharing that for a moment. All right, so I'm just going to continue. And so the next matter we need to look at is the idea of what is a caveatable interest. And you'll see that's discussed at paragraph 5.169 in your casebook. And this is important because that's essentially the basis of how you qualify to lodge a caveat, okay? And we can see there that the caveats are in relation to lots under the LTA, and they necessarily relate to estates or interest in land. However, it's important to note that it's not necessary for a caveatable interest to be a registrable interest. What is required is the caveatable interest is one which equity will give specific relief for. So again, this is an indicator that what the basis upon which the caveat is being lodged is that you actually have an interest that's recognisable in equity. Have a look at those sections which deal with a caveat lodged by a registered proprietor, that's 122 and 126. A question arises in a situation where a mortgagee has exercised their right of a power of sale fraudulently, and how that works in terms of the caveat provision, so you can reflect on that. Section 130, which deals with compensation for an improper caveat, just important to realise that that's the relevant provision, as I already indicated, in Queensland, and in that it would appear that the onus of proof in relation to a caveat under 130 is in fact reversed to how it operates in most other jurisdictions. You can see there that there's this idea of that it wasn't lodged without reasonable cause, and there seems to be a suggestion also that it needing to establish that it wasn't lodged for an improper purpose. So there's obligations being set here upon the caveator, that is the entity lodging the caveat, in relation to that caveat process. And again, we're just pointing out what are the relevant provisions in Queensland that set that up, and there's an indicator here that it doesn't operate necessarily the same in all jurisdictions. Right. So from there, we look at the idea of the requirements of a caveat, and the decision in Kirribilli Park, which, as you can see, is referred to there in your textbook at 5.172 and 174, is discussed along with the relevant features of the situation as it's applicable in Queensland. So you can see there's through the diagram, you can have a look at the facts going on in the Kirribilli Park case, which is a 1978 New South Wales decision, and so not directly bearing on the Queensland provisions, but it's helpful in terms of thinking about requirements. what we found is that, and important to note that even in New South Wales, there's been some adjustment to the legislation following the Kirribilli Park case, that the judge in that case pointed out that the right to caveat is given by statute, not for the purpose of giving notice to the world of a claim of the caveator's interest from being defeated by the registration of a dealing, protecting the caveator's interests from being defeated by registration, but to invoke the assistance of the court to give effect to the interest. So the idea here is that what is the role of the caveat? The caveat's been described as nothing more than statutory injunction to keep the property in status quo until the court has an opportunity to discover what the real rights of the parties are. And if this is the correct understanding of how a caveat operates, the judge is pointing out here that it would seem to follow that a caveat should have no right to prohibit registration of a dealing to which his alleged interest in the land would not entitle him to object. So the point that Holland's making is that what's going on, I'll just move on from that to the Queensland position, but what's going on in the Kirribilli Park case is it's helping us to think about, well, what role does the caveat play? We'll see that there's some further case law that we're going to look at shortly or momentarily in that regard. What role does it play, and how do we need to understand how much it gives to the entity lodging the caveat on the one hand, and the role of the court on the other, in that being a mechanism for the court to look at the nature of the interests that the caveat is seeking to support that actually aren't registered interests under the system. We need to appreciate that despite those statements in Kirribilli Park, the requirement for caveats is governed by the relevant provisions in Queensland under the LTA, Part 7, as we've seen. Also, just need to emphasise that the operation and effect of the LTA is a bit different to other jurisdictions. So under the LTA, when the caveator, which is the person whose assets a caveatable interest is linked to, has lodged a caveat, the caveator must take legal action to establish the validity of the claim under the caveat. So lodge the caveat under the system, then legal action must be undertaken to pursue the interest that the caveat is seeking to support. There's also under Section 126 a time frame. You can see there 3 months within lodging the caveat. And the caveatee, that is the person against whose interest the caveat has been lodged, maybe it could be the registered proprietor, could be another interest, could be a registered mortgagee, for instance, registered leasehold interest, possibly, can serve notice on the caveator to commence legal action to establish the interest alleged under the caveat. So the point is that under the Queensland arrangement, there are things that must take place and there's a timing. And if that hasn't occurred, then the caveat and its work in providing a protection for this unregistered interest will founder. So just important to be aware of that and that situation in Queensland. Right, so continuing on with the idea of caveats, removing caveats is dealt with under Section 127, and I've already shown you that section. Okay, and if you go back and have a look at Section 127, it looks at the caveatee may at any time apply to the Supreme Court for an order that a caveat be removed. The Supreme Court may make the order whether or not the caveator has been served with the application and may make the order on the terms it considers appropriate. So broad powers within the Queensland Supreme Court there in relation to the removal of the caveat, and also this idea that we need to determine whether there has been a reasonable basis or a reasonable cause, as the legislation refers to, for the lodgement of the caveat. And if there hasn't, then that will be certainly clear grounds for its removal. And that's something for the court to determine. You can see the idea of caveats lodged without reasonable cause on pages 545 through to 547 in your casebook. All right, so get a sense of that framework of caveating, the caveating provisions, the role that they play in relation to unregistered interests. We then need to think about, well, when we've got interests off register, and these are interests recognised by equity, so equitable interests, what do we do? How do we deal with this competition issue, right? And then we're going to ask, we come forward a bit, we're going to ask, well, what is the purpose when we get to these subsequent cases, which are documented there? What is the purpose of the caveating provisions in these competing equitable interest scenarios? Okay, and there's a bit of a variance, a little bit of a variance of perspective on that, but there is also some strong judgments indicating the role the caveat plays. So we start with the first case here, and again, in terms of competing equitable interests, you will have seen in your studies in equity that there's the general law governing the competition of competing equitable interests under Rice and so on. We're asking, how does that work in the context of Torresn land with the implications of the registration under the Torresn framework, and how does that change how we understand the competing equity type of situations? Now, we go to, stop screen sharing that for a moment. Right, so I'm just going to continue screen sharing the slides. So we've got this early decision, Privy Council decision on appeal from the High Court at a time when that was possible. Abigail and Lappin, and basically we've got a situation in Abigail and Lappin where we've got a scenario of competing equitable interests. And the Privy Council is trying to resolve how it should tackle this, and you've got the statements by Lord Wright. And Abigail and Lappin, you'll find, is dealt with in your casebook at 5.180 capital C. And a few pages there, so from 547 basically through to 553 for Abigail and Lappin. You basically got Lord Wright coming out and agreeing with the position of Gavin, Duffy and Stark in the High Court. And they concluded that the Lappins were bound by the natural consequences of their acts in arming Mrs. Heavener with the power to go into the world as the absolute owner of the land and then execute transfers or mortgages, for example, of the land or to other persons. That they ought to be, and they ought to be postponed to the equal rights of Abigail. So if we just take a step back for a moment. And what was going on in Abigail and Lappin was that we had a husband and wife, registered proprietors of separate parcels of land, executed memorandum of transfer in favour of a nominee they had, which was a solicitor. The memorandum was executed as security for certain costs and payment of sums due to the bank. So that was the way things were done in those days in some situations. As the matter was ultimately viewed, the respondents in executing or handing over the memorandum of transfer had authorised the solicitor to deal with the property, but not for his own benefit, but for the nominee of his nominee otherwise than as mortgagee. So the solicitor had the documents for what purpose? To act on behalf of those he was dealing for. The transfer subsequently registered in breach of that authority. So basically, the solicitor had breached his authority in terms of dealing with the documents. Transfer became the RP of the fee simple in each parcel of land. And after other dealings, the appellant lent money on the security of the registrable memoranda of mortgage of the land executed by the registered proprietor and of the deposit with him of the duplicate CT. Caveats by the respondents prevented registration of these memoranda of mortgage. Respondents sued the appellant and others claiming that they were entitled to an order that the RP should transfer the land to them free of encumbrances. So basically, looking at the husband and wife who were the original registered proprietors seeking to have the land transferred back free of encumbrances of these mortgages that had been entered into by the solicitor, which had actually, basically done the wrong thing. So that's how Lord Wright looked at this. He was going back to the views of Gavin, Duffy and Stark in the High Court in terms of, well, the Lappins, what they did. They gave, they should be bound by the natural consequence of their acts. They armed Heavener with the power to go into the world as the absolute owner of the land and execute transfers and so on, and mortgages and enter into those things. Privy Council also took the view that Butler and Fairclough was rightly decided. It's an earlier decision, and in that context they endorsed the view of Chief Justice Griffith, who said that apart from priority in time, the test for ascertaining which encumbrancer has the better equity must be whether either has been guilty of some act or default which prejudices his claim. So they're looking at the conduct of those equity holders and looking at how that's to be assessed. In the present case, the respondents on the one hand, this is in the Butler in all the circumstances in Abigail and Lappin. In the present case, the respondents on the one hand enabled the Heaveners to represent themselves as legal fee simple owners, so going into the world and arming themselves in that way. While on the other, it cannot be said that Abigail did or omitted to do anything which he should have done in lending the money on the security, though he might be registering the mortgage and have secured the legal title. It may be that he accepted Heavener's word that he or his wife were registered as having legal title, but that was a true statement and no search or inquiry that could have been made would have displaced it. So the point that we get here is an early response in thinking about the nature of these competing equitable interests, and to some degree the notion that how does caveats work a little bit. The response in terms of this situation was that Abigail had been misled by the representations of Heavener to the effect that there was no outstanding equitable interest over the land. To that extent, failure to lodge a caveat was superfluous to the question of postponement for the Privy Council in this instance. So the fact that a caveat wasn't lodged actually didn't change the situation. That's something to be noted here. But the relevance of Abigail and Lappin as an early decision is just helping to guide us to some degree in terms of how do we understand the situation under Torresn, where we've got actually competing equitable interests. So from there we update, we come to a more recent High Court decision in Hyde and Reliance Finance. Now in this case, we don't need to go too far into the facts of the case, but just to be aware that basically what the court is reinforcing is a more general and flexible principle that preference should be given to what is the better equity in an examination of the relevant circumstances. So rather than focusing on the conduct of the earlier equity interest holder or equitable interest holder that might justify postponement of that earlier equitable interest, the court in Hyde and Reliance Finance, which is in 1983, the High Court, is saying, well, look, what's a better view is to examine all of the relevant circumstances. It will be necessary to characterise the conduct of the holder of the earlier interest in order to determine whether, if in all the circumstances, the conduct is such that in fairness and in justice, the earlier interest should be postponed to the later interest. So yes, we're looking at the order, the priority issue, but it's a question of looking at the totality of the situation. But again, in terms of an outcome that is about postponing the earlier equitable interest holder. Now, there's noted there that we now also need to be mindful of the AGCQ and A&T promotions case. It's a 2010 decision of the Queensland Court of Appeal. This is an important case because, and it's discussed in your case book, at paragraph 5.190. It's important because the Court of Appeal in that case emphasised that we should be looking at the conduct of both interest holders and making decisions about postponement in terms of that complete picture. And there's also a factor in terms of caveating and the role of caveating. And we've seen earlier that, in that early decision, this, well, does caveating have an impact or not? And this is a bit of an ongoing saga, really. And this comes up again in this context. So we just need to be mindful of that decision in terms of its impact around how we generally view the competition of equitable interests in regard to Torresn land. We come then to the decision of J&H Just in terms of retaining title deeds. Now again, that point stop screen sharing that for a moment. All right, so let's continue screen sharing slides. So in the J&H Just case, in terms of this idea of who retains the title deeds, and you'll see that discussed on pages 555 to and following, but the facts are on 555 to 556. Situation involving the creation of a mortgage and who was holding the title deeds in relation to the property, party being the RP, and dealing with a bank in relation to that, of course, where was the title documents held, and they were at the bank for safekeeping, and then there was no inquiry made in relation to that, and then at a later period, about 3 years after this incident first arose, there was a lodgement of a caveat, and then the RG had to look at that situation to see whether the mortgage was entitled to priority, whether the equitable mortgage was entitled to priority over the interest that the bank held. You can see on the slide that that's generally explained in a diagram for you. The significance of this case lies in the comments that were made by Barwick in relation to the role of the caveating process. And you can see even in that, I've documented for you some comments and implications with regard to what was said in Abigail and Lappin, or Lappin and Abigail, which was the High Court decision before it went on appeal to the Privy Council. And this arose out of New South Wales situation, so looking at the New South Wales provisions of the relevant Real Property Act there. But these comments by Barwick are the things that we have an interest in. And I've reproduced some of this for you on the slide. So Barwick's essentially looking at the idea of an unofficial caveat. He's talking about an unofficial caveat as not a caveat that's lodged by the Registrar General, like so-called official caveat. And he's saying that the purpose here is to act as an injunction to the RG. In this case, the RG is the office that manages and administers the Torresn system, to prevent registration of dealings with the land until notice has been given to the caveator. That's with the caveatable interest under the caveat. This enables the caveator to pursue such remedies as he may have against the person lodging the dealings for registration. The purpose of the caveat is not to give notice to the world or to persons who may consider dealing with the registered proprietor of the caveator's estate or interest, though if noted on the certificate of title, it may operate to give such notice. If the caveator does not take proceedings in due time against the person who has lodged a dealing for registration, and the dealing is registered, awareness of the existence of the caveat, and through it, that an estate or interest is claimed by the caveator will be irrelevant, except possibly as an element in establishing fraud in procurement of registration. But of itself, such awareness will not vitiate registration. So this idea of having notice of interests outside the register is part of this, okay? The focus for Barwick was actually on the conduct and the behaviour of the parties, not whether they caveated or didn't caveat. It was the respondent's conduct in thus arming the mortgagee with the capacity to become the registered proprietor and able to deal with others as such, and not the failure by them to lodge a caveat that was decisive. He goes back to Abigail and Lappin and says that's really the critical finding that comes out of Abigail and Lappin. And he continues, whilst it may be true in some circumstances that the register may bear on its face a notice of equitable claims, this is not necessarily so, and while in some instances a caveat of which the lodgement is noted in the certificate of title may be noticed to all the world that the registered proprietor's title is subject to the equitable interest alleged in the caveat, this, in my opinion, is not necessarily universally the case. It is not, in his view, in Barwick's view, in the Just Holdings case, it's not a mandatory requirement, even though as we've seen, the provisions are there in the legislation. Okay. He goes on, to hold that a failure by a person entitled to an equitable estate or interest in land, in this case under the Real Property Act, because the appeal was coming from New South Wales, to lodge a caveat against dealings with the land must necessarily involve the loss of priority, which the time of the creation of the equitable interest would otherwise give, is not merely, in my opinion, unwarranted by general principles or by any statutory provision, but would, in my opinion, be subversive to the well-recognised ability of parties to create or to maintain equitable interests in such lands. Strong statements by the former Chief Justice that this is the role that caveats play. They are an instrument, or they are a tool, if you like, in the armoury that equitable interest holders can engage under the system to provide protection, but they essentially have a protective function. Right? Now, we come forward a bit and we see further that in any case, again, Barwick is saying the failure by such a person to lodge a protective caveat, so he's focusing on this idea that the rationale of the caveat is protective, cannot of itself properly be held to be an act fulfilling the requirements to which I have referred of conduct which will deprive the prior equity of its priority. Failure to lodge a caveat doesn't mean that the prior equitable interest holder loses priority. It's not a fundamental requirement according to Barwick in the Just case. Okay. He emphasises the purpose of the caveat is protective, not to give notice to all the world. So to some degree, he's distinguishing himself from earlier views about that, but he actually says that he's consistent what the Privy Council decided in Abigail and Leopard. When we come forward from there, you will see that paragraph 5.186 in your casebook, there's reference to the much more recent High Court decision in Black and Garno. Now, just should be noted, and this is the authors indicate, in Black and Garno, Gleeson cited with approval the view of Barwick in Just's case as to the purpose of the caveat. However, Justice Callanan, no longer on the court, but Justice at that time, Justice Callanan expressed strong disagreement. Callanan said that the caveat served both as an injunction to the register and to give notice to anyone serving the register that another dealing or transaction was on foot. So we have a difference of opinion here about the role of caveats. It's something for you to think about. Under the Queensland framework, which is not identical in other jurisdictions, and we saw that the Just case came out of New South Wales, how should we perceive the role of caveats? And going forward, in the electronic environment, is Barwick's claim, does it continue to have justification? That it is just one mechanism and that the failure to lodge a caveat doesn't displace the priority of an earlier equitable interest holder, if we've got competing equitable interests that are equivalent otherwise in terms of their quality of entitlement, as recognised by equity. Because we then also need to appreciate that in Queensland, as I mentioned earlier, we have the settlement notice provisions under Part 7A, sections 138 to 152, and you need to look at those. These provide protections, clear protections between entering into contract and prior to settlement on a transaction, and you need to see how they're different to the caveating provisions and how they might provide an alternative to the caveating provisions in some circumstances. So have a look at those and a review of those. And then lastly, the provisions for compensation for loss are dealt with starting on page 577 of your casebook and going forward, but some of that material again tends to focus on from the other jurisdictions. Our concern here is on the provisions in Queensland. I'll just stop screen sharing that for a moment. I'll screen share the legislation as we've been doing. We come to, so section 188, see that we've got the compensation provisions, 188 dealing with compensation for deprivation of a lot or an interest in a lot, loss or damage, compensation for which a claim may not be made, 188AA, so you can see there's been amendments to these provisions, ordered by the Supreme Court about deprivation, time limits, and matters for which there is no entitlement to compensation. Quite detailed, you can see there under 189. And then 190 dealing with the state's right of subrogation, which you can have a look at. So have a look at those provisions. Just stop screen sharing that for a moment. Have a look at those provisions dealing with the compensation provisions, and also, as I mentioned to you earlier, be mindful of the implications of how the system is being differently managed. Not in Queensland, still managed by the Land Titles Registry as part of the Queensland Department of Natural Resources and Mines, but in other jurisdictions becoming under a more privatised or commercialised environment. Right, so there we are, folks. That's the third topic, the final topic on the Torresn system. And we've looked at unregistered interests, we've looked at equitable interests, we've looked at competing equitable interests. We've looked at critically the role of caveats and also the idea of priority notices under Part 7A of the Land Title Act. And then lastly, we've considered just briefly, the arrangements with regard to compensation for loss under the Land Title Act provisions. So that brings us to the end of our topics on Torrens title. But as I said, the ideas and the concepts of the Torrens system abide through the remaining topics in the unit, because all private freehold land in Queensland is Torrens land. So until the next topic, bye for now.